When looking for a solution to deal with problem debt, people will often wonder how filing a proposal or bankruptcy will affect their spouse, and if their spouse will be held liable for their debts. Hi, I'm Maureen Parent, a licensed insolvency trustee with Michalos and Associates. In general, a consumer proposal does not affect your spouse unless your spouse co-signed or guaranteed the debt. Your spouse's credit rating will also not be affected just because you filed a proposal on your debts. But doesn't being married mean your debts are joint and your spouse will be on the hook for any debts included in your proposal? Thankfully, no, not necessarily. A marriage or common law relationship does not make you legally responsible for your spouse's debts. You are responsible for the debts in your name. Your spouse is responsible for the debts in their name. Co-signing a debt or guaranteeing a debt means the debt is in both the names of the borrower and the guarantor or co-signer. If you co-signed or guaranteed your partner's debt, then you're equally liable to repay the full debt if your spouse stops making payments. Sometimes people assume joint debt means they're only required to pay back half the debt. That's not the case. If you're joint, you are responsible to repay 100% of the remaining balance. In practice, if you're not paying your joint debts, the creditors will look to the co-signing spouse to continue to make those regular monthly payments. So what happens if one spouse files a consumer proposal? Can a creditor come after my partner? Well, that's a good question. A consumer proposal is a legally binding debt settlement agreement filed with a licensed insolvency trustee to repay your creditors a percentage of what you owe in exchange for full debt forgiveness. A consumer proposal deals with unsecured debts you are liable to pay. This includes debts you owe and debts you owe jointly with another person. If you do not have any joint unsecured debts with your spouse, they will not be affected by your filing of a consumer proposal or a bankruptcy. Your creditors cannot contact your spouse for your debts, but your creditors can contact your spouse if your spouse co-signed or guaranteed the debt. Common unsecured joint debts are lines of credit and credit cards. In the case of supplementary credit cards, they sometimes come with fine print, always, stating that by using this card, you are agreeing to be liable for it. If you have a secondary credit card and your spouse is a primary card holder, you might be liable for the entire balance. So to be certain, the best thing to do is to call the credit card company to see what you're liable for. As I've mentioned, if you have joint unsecured debts, then your spouse will be expected to pay that debt off in full, even though your debts are being compromised by the consumer proposal. While your proposal protects you from further collection actions by estate proceedings, the joint spouse is not protected unless they too file a bankruptcy or proposal. If you have a significant joint unsecured debts, make sure you discuss that with the trustee because it may make sense for both of you to file a consumer proposal or one to file a bankruptcy and the other to file a consumer proposal. It is important to know that unlike a bankruptcy, in a consumer proposal, you keep any assets you own. However, the value of any assets you own will be factored into the offer made to your creditors. For jointly owned asset, only your half interest is considered when looking at your options. As you keep your assets in a consumer proposal, it is a good option, especially when those assets are jointly owned. To learn more about what your options are to become debt-free, visit us at hoys.com.